Appearing in the bill of Great Asia Maritime Limited against Orion Shipping and Trade LLC.
Yes, Mr. Francis.
Lord Grofel. Lord, I appear on behalf of the appellant sellers, my friend Mr. McHenry, and my friends Mr. Lewis, KC, and Ms. Bond. I appear on behalf of the respondent buyers. We've agreed an equal division of time, 1/4 hours each. My plan is to go for about 2 hours this morning, leaving 15 minutes or so for rebuttal.
Are we to have contributions from juniors?
I understand that Ms. Bond will be dealing with the respondent's notice on their side. I'm afraid you're stuck with me for the duration. Lords, obviously, as you have seen, this case involves a contract for the sale of a ship on the 2012 Norwegian SALEFORM form. It was decided by the Court of Appeal, and it's now common ground, that sellers are under a readiness obligation. That's an obligation to exercise due diligence, to tender NOR, and be ready to deliver by the cancelling date. That readiness obligation, as we've called it, is an innominate term. It's not a condition of the contract. On the facts, the sellers were twice in breach of that readiness obligation. On the first occasion, the buyers agreed a new cancelling date. They lost the use of the vessel for a considerable period due to the late delivery, and they were awarded substantial compensation pursuant to Clause 14b for their loss of profits during that period of delay. Of course, that part of the award, awarding compensation for delay, is not challenged. Sellers were not ready by the second cancelling date either. By that time, the market had risen, so the vessel was worth more than the contract price. The buyers didn't, however, agree a new cancelling date. Instead, they exercised their Clause 14a right to cancel. Now, you may have seen that the facts were somewhat unusual in that the buyers did not, in the usual way, send a notice exercising their right to cancel. What they did, in fact, was arrest the vessel. But the tribunal held that the arrest of the vessel was a valid acceptance of the express contractual right, or an express exercise of the express contractual right to terminate. And nothing turns now on the fact that they exercised the right to terminate by an arrest rather than a simple notice exercising that right. I say it's somewhat unusual, perhaps, for buyers to terminate, notwithstanding that the market had risen. It was decided by the tribunal, and it's not challenged on appeal, that while sellers were in breach of the readiness obligation standard of due diligence, and thus were negligent in not being ready, they were not guilty of any repudiatory or renunciatory breach, and of course were not in breach of any condition of the contract. As in our written case, I'll tend to use repudiatory breach as a shorthand to include renunciatory breach and breach of condition in all submissions. On the facts, far from committing any renunciatory breach, sellers had made it clear that they intended to perform. And you can see that in paragraph 140 of the award, which is at page 176 of the key documents bundle. I'll give you the reference, but there's no need to turn it up. It's paragraph 140 at page 176. So the issue is whether, in those circumstances, buyers having cancelled the contract by exercising an express contractual right to cancel, but in the absence of any repudiatory breach, Clause 14b entitles buyers to recover compensation for loss of bargain. That's the issue which the court has to decide. I wanted to turn to the Memorandum of Agreement itself, which is in the core documents bundle at page 1253. But while we look at the MOA, I'd invite the court to look at it with two general principles in mind. I'll come back later to the authorities which we say clearly establish these two principles. The first I'll refer to as the causation principle, and the second I will refer to as the clear words principle. The essence of the causation principle is that if there is a repudiatory or renunciatory breach, that breach destroys the contractual bargain or goes to the root of the contractual bargain, putting it away, and thus, as a matter of law, causes the loss of the contractual bargain. And that is inherent in the nature of a repudiatory breach. It's a breach that deprives the other party of substantially the whole benefit of the contract. It's obviously the Hong Kong Fair test.
But only if it's accepted.
Well, with respect, no. If it's accepted, then the contract comes to an end. But if it is not accepted, if the breach itself is sufficiently serious as to deprive the innocent party of substantially the whole benefit of the contract, then because that is the nature of the breach, of itself, it means that the original contractual bargain can no longer be fulfilled. If the innocent party does not accept the breach and some performance continues, the performance that continues is not the original bargain. The original bargain has been lost by definition because the breach has deprived the innocent party of substantially the whole benefit of the contract.
I'm not sure I follow that. I mean, if we've got a repudiatory breach, you either accept it or you don't accept it. If you don't accept it, the contract carries on and it can be fully performed thereafter.
Well, it will not be the original contractual bargain, however, because the performance that follows will be a performance which has substantially deprived the innocent party of substantially the whole benefit.
Doesn't that depend what the nature of the repudiatory breach is? I mean, if, for example, the settler blows up or scuttles the ship, I can quite easily understand your point that the contract is never going to go to completion in the way it was originally contemplated.
Yes.
But if he simply says, well, actually, I no longer have any intention of bringing the ship to the delivery place on the due date or at any date,
yes,
that's a sort of renunciatory type of repudiatory breach, which is, if not accepted, a thing writ in water, so that the buyer, if he could ask for specific performance or exercise all his contractual remedies.
Well, but if there is a renunciatory breach, but pursuant to which the contract breaker is not going to perform,
He says he's not going to perform.
Yes.
He may be dragged to court kicking and screaming and made to perform.
Well, in the case of an order for specific performance, then yes, I accept there would be performance of the original bargain. But where you have a repudiatory breach, a past repudiatory breach, which by its nature deprives the innocent party of substantially the whole benefit of the contract, it follows that it is the breach itself that has destroyed the original bargain.
So, I mean, I have the words writ in water going through my mind, as I'm sure anyone does when talking about an unaccepted repudiatory breach. Is this an inroad into that principle, or is it just that that principle only applies to breaches which don't, for example, destroy the subject matter of the bargain?
Now, any repudiatory breach which is identified and classified as a repudiatory breach, using repudiatory breach in the strict sense, which is a breach which has already deprived the innocent party of substantially the whole benefit of the contract, is more than a thing written in water, because the fact of the breach itself has already, as I say, by definition, deprived the innocent party of substantially the whole benefit of the contract.
And the relevance of this point to this case is what?
Well, the relevance is that we say that where, in circumstances in which the innocent party is entitled to loss of bargain damages, is where the breach causes the loss of bargain. If the breach is not repudiatory or renunciatory, not a breach of condition, then the breach does not cause the loss of bargain. If the innocent party exercises an express contractual right to terminate, then it is, as a matter of law, the exercise of that right to terminate which causes the loss of the bargain.
Well, I can see that argument, except for the fact that you've got an express contractual right to compensation for their losses and all expenses.
Well, due compensation for their loss and all expenses.
Yes.
Yes.
So ordinarily you exercise an option, you get your deposit back, and you're no longer a party to the contract. But here you've got an express contractual right.
Yes, but the question is whether the express contractual right in 14b, due compensation for their loss and all expenses, is sufficient to create a right to recover bargain damages.
What does it do then?
Sorry?
What does it do then? What damages could you recover?
Well, if there is has been a repudiatory or renunciatory
No, if the buyer exercises the option to cancel the agreement,
yes,
what do losses cover then?
the loss will be any loss that has occurred during the period between the date on which the vessel should have been delivered and the cancelling date. And in addition...
So accrued losses?
Yes, and in addition, he recovers all expenses, which we say is sufficient to include wasted expenses and reliance losses in essence.
Okay.
But one has to remember that the provision applies...
And would that cover losses caused by providing for a crew to arrive at a certain time, which would only become a loss after you've exercised the option?
Well, it's not necessary for me to advance that argument as part of this case, which is focusing on loss of bargain damage.
Well,
I would say that it is sufficient to enable the buyer to recover those wasted costs because of the contrast in 14b between, if we look at 14b, it's at page 1261.
Sorry, page?
1261.
Thank you.
And so obviously it's clause 14a, which we referred to as 14a, which is lines 338 to 345, which creates the contractual right to terminate. If we look at 14 in two parts, 14a, the essence of 14a is creating the contractual right to terminate. We might call it an express termination provision or express cancellation provision. And then lines 346 to 349 are the express compensation clause. And as it says, it applies whether or not buyers cancel this agreement. Now, if buyers don't cancel, then they will be entitled to recover damages for their loss caused by the delay in delivery. It's important to remember that the obligation, the readiness obligation, is an obligation to be ready to deliver on time. It's an obligation that goes to time of delivery, we say, rather than resulting in non-delivery or breach, being akin to non-delivery. I'll take you to the relevant passages in the judgment in relation to that in a moment. So, in either case, whether there is cancellation or not, the innocent party can recover damages for their loss caused by the delay, which is the loss that is caused by the breach, and they recover their all expenses. But we say if the breach has been a repudiatory or renunciatory breach, then applying basic common law principles, they would also recover loss of bargain damages if they cancel. The question, as I said, that the court has to grapple with in this case is, is that express compensation clause in lines 346 to 349 sufficient to reverse what would be the common law position and create a right of recovery in respect of loss of bargain damages in respect of a breach which is not repudiatory or renunciatory?
So as I understand, just going back to the point you're making about causation.
Yes.
You're resting your analysis on the fact that there is a difference between an express termination clause and termination at common law. And as I understand it, your argument is that if you pursue termination under the express contractual termination clause, you cannot recover loss of bargain because you say the loss is not, that loss is not caused by the breach, i.e. the repudiatory breach. It's caused by the exercise of the contractual termination right.
Yes. Sorry.
Yeah. And that presumably is the financings and Baldock type of analysis, is it?
Financing and Baldock, it's summed up very succinctly in the cause, in Lord Sumption's judgment in the cause. It's also set out clearly in the Australian authorities, AMEV, which is in the bundle and referred to in our skeleton, and we provided a copy yesterday of Cheval, which is to the same effect. But there are numerous cases, and it's accepted in the textbooks, that where there is no repudiatory breach, but the exercise of a contractual right to terminate, whether that contractual right to terminate arises because of a breach which is non-repudiatory or is not dependent on a breach at all, then as a matter of law, the cause of the loss of bargain is not the event which triggers the non-breach event which triggers the right to cancel. It is not the non-repudiatory breach which triggers the express right to cancel.
And then I think the point being put to you, effectively, Lord Hamlin first put it, is that in both situations, what is causing the loss might be said to be the exercise of the choice of the innocent party to terminate the contract.
Yes.
And that therefore the causation argument resting on, oh well, that's because you have chosen to exercise that, looks potentially suspect, does it not?
Well, with respect, it doesn't look suspect because it is the innocent party's choice that causes the...
So it is in a repudiatory breach?
Well, in a sense...
That's the point I'm putting to you.
Yes, in a sense, yes. But the law views repudiatory and renunciatory breaches differently because the effect, the nature of the repudiatory or renunciatory breach is to go to the root of the contract. The law treats the exercise of the choice by the innocent party differently in the two circumstances.
Yes, thank you.
Just going back to the meaning of loss, in a situation where you do cancel, is it different to the situation where you don't on your case? What loss covers? You said it covers delay in delivery.
Yes, it will be different if there has been a repudiatory breach and the buyer cancels. Because if the breach which triggers the payment of compensation pursuant to 14b is sufficiently serious to constitute a repudiatory breach or renunciatory breach, then the law treats that as being the cause of the loss of bargain.
Right, well, you get damages anyway there. So what is loss adding to it? Anything?
in that situation, not a lot is the answer. But this is where we perhaps come on to the clear words principle, which is that the parties contract against an established framework of rights and obligations. And it requires clear words to achieve a result which is materially different from that established framework of rights and obligations. Obviously, the more different the proposed outcome is, the clearer the words have to be to achieve that effect. And we say...
This is your Noverson presumption.
We've labelled it the Noverson presumption. It's really, we would say...
That's your label, is it?
It is.
Nobody else has labelled it that.
Correct. But I mean, we've applied that label because it's clearly stated in the judgment in the Noverson case. Really, it's simply either part and parcel of the Gilbert-Ash presumption or an analogous presumption to it.
But does it apply to any change to what otherwise would be your common law rights? Or?
Yes, we say it's a principle of general application, but clearly the more radical the departure from the established framework, then the clearer the words need to be to succeed in achieving that departure. What we do say is that it is a very radical departure indeed from the common law framework to hold that a party that exercises a contractual right to terminate is entitled to recover loss of bargain damages in circumstances where there has been no repudiatory conduct, no renunciatory conduct on the part of the, in this case, the seller. Perhaps the passage in which it's most clearly shown to be a principle of general application is in the judgment in Triple Point Tech, which is in the main hearing bundle at page 806. It's tab 30 if you're working from tabs of bookmark 30. And the context was that there was a clause in the contract which provided a cap on liability, but there was a carve-out for liability resulting from, amongst other things, negligence. And the question was whether negligence was to be given its ordinary meaning, which included failure to comply with a contractual duty to perform with reasonable care, or whether the carve-out was limited to cases of liability caused by a freestanding tort. But the analysis of the clear words principle appears in the judgment of Lord Leggett, with which my Lord Burrows agreed, at page 845 of the bundle.
This is under the heading Clear Words.
Clear words needed to restrict valuable rights.
Where do you want us to read?
If you read from 106 to 108, please.
That appears to be rather different. It's about the taking away of rights and remedies in the common law.
My submission is broader than that, because if one looks at the very foot of 845, Lord Legate says, it also remains necessary, however, to recognise that a vital part of the setting in which parties contract is a framework of rights and obligations established by the common law, often now codified in statute. These comprise duties imposed by the law of tort and also norms of commerce which have come to be recognised as ordinary incidents of particular types of contract or relationship, and which often take the form of terms implied in the contract by law.
But I mean, someone just reading those paragraphs might think that the best label to give this was a sort of anti-derogation principle. But the issue here is whether additional rights have been conferred by the use of the phrase compensation for loss.
But it's a derogation from the established framework of rights and obligations, because the established framework of rights and obligations is clear that one does not get loss of bargain damages, unless there is a repudiatory or renunciatory.
You get more.
Yes.
Not less.
Yes, but it is a derogation from that framework.
It's a funny kind of derogation when you get more rather than less.
Well, any advantage conferred on one party is a disbenefit conferred on the other. I mean,
so it is, but the phrase that, I mean, Clause 14 is all about conferring rights on the buyer.
Yes.
It's not about derogating or not derogating from rights of the seller.
Well, I mean, one way of looking at it is that the common law position is that the seller can be in breach, but so long as he is not in repudiatory or renunciatory breach, he is not going to have to pay loss of bargain damages. And the creation of a right to claim loss of bargain damages in the buyer, the other side of that coin is it is a removal of a benefit that the seller has as a matter of common law, as part of the established framework.
It's a rather odd way to approach construing a contract, to take as your starting point that the parties wanted the common law, which is effectively what you're asking us to do. Well, the parties want the common law unless they make it very clear they don't. Well, that's what you're saying.
Well, in my submission, that is what Lord Legate is saying. It is that you contract against an established framework, and there is a presumption that the established framework will apply, unless there is a clear derogation from that established framework. And
can I just check, that's my own ignorance, is the Norwegian form only used where it's governed by English law?
Well, I mean, the answer to that is no, because the parties obviously could use the form to vary the choice of law clause.
But the choice of law is built into the form.
There's the standard form, the choice of law clause.
Okay, that's
is clause 16, which is actually on the same page below the clause 14.
Yes, got it. Yeah, thank you. Well, that's for the MOA, but is this absolutely standard Norwegian form?
That part of it is, yes.
Yeah, okay.
Yes. There is a choice. Well, sorry, I don't know if it's absolutely right. The standard form has two parts, it's A or B. Part A, clause A is...
So what page are we on?
It's 1261.
Yeah.
So clause A is choice in favour of English law and LMA arbitration. And clause B, which has been deleted in this case, is for New York law and New York arbitration.
But the principle you're putting forward about not derogating, as it were, from common law rights is a principle of general application that would apply to every single contract there is.
Yes. I mean,
so
but it's
every single contract has got to be drafted with particular care to make it absolutely clear that additional rights are being conferred.
Well, the greater the derogation, then the clearer the words have to be to achieve the result of derogation. And one mustn't get carried away and think this is some sort of impossibly high bar. I mean, clearly this contract itself derogates very substantially from the common law position because it creates a right to terminate where there is no breach at all.
But I mean, again, it's a very strange way of using derogation. It gives a right to terminate where the common law wouldn't give you a right to terminate.
Difference might be a better word than derogate.
Yes.
Well, or departure.
Well,
the whole point about a contract is that the parties don't just want to rest on the common law relationship, which may be, if there's no contract at all, it would be a tort relationship.
yes.
They want to do something contractually which is different from what the ordinary law might otherwise provide. I mean, take the case of a professional retainer, where there's an underlying tortious obligation, but they want a contractual regime.
Yes.
And that's surely the same in any contractual situation. The contract is going to depart, in some respect, from where the parties would be if they were just left to their common law rights.
Well,
And if every benefit to one side is a derogation from the other side,
this benefit,
and as my lord said, you end up having to have the clear words principle applying to every line of every contract.
well, in my submission, in a sense, it does, but most contracts and clauses are clear. The critical factor here is that there is an express compensation provision which is radically different from the position that would apply, if my friend is right, is radically different from the position that would pertain at common law. The position at common law is that absent a repudiatory or renunciatory breach, the non-repudiatory breach, where it is followed by an election to cancel, is not seen as, not treated as a matter of law as being the cause of the loss of bargain, and loss of bargain damages are not recoverable.
So contracting parties just couldn't rely upon reading the contract. They would have to actually understand what the differences between the contract and the common law were, and then they would have to understand whether the differences were substantial or insubstantial, and then they would have to work out whether clear words were used to change the common law position. A long way removed from just simply reading the contract.
Well, the parties to a contract are deemed to know the law. That's the knowledge of the law is baked into an interpretation or construction of contracts. And we say again, it is a fundamental principle of common law that a non-repudiatory breach, a non-renunciatory breach, does not sound in loss of bargain damages. And the law is, the case law is very clear that even where a contractual right to terminate is exercised, in the absence of a repudiatory or renunciatory breach, there is no recovery for loss of bargain damages. And so one has to ask oneself the question, in the light of Triple Point and the other cases that we've cited in relation to this principle, whether the words of the clause are sufficiently clear as to reverse what is a very clear common law position.
Is there any authority on clauses, contractual clauses, which either make or enable a party in certain circumstances to make time of the essence for the performance of a contractual obligation, where the general common law position is that time is not of the essence? Has the clear words principle ever been applied to clauses of that kind, so far as you know?
I'm not in a position to answer that question from one way or another. One area where the clear words principle is applied, and this is, we say, important in this case, is in relation to the construction of clauses as conditions.
sort of before leaving the clear words proposition, it might give birth to an additional clause in standard contracts, and that is that if there are any differences between this contract and the common law, we have sought to and wish to apply clear words to exclude the common law position. And so the draftsman would attempt to get round the proposition you're putting forward. And contracts would become even more complicated.
Well, I mean, one could certainly insert a clause to that effect, or one could insert a clause to you know, in the sense, in some ways, if you have a clause that says you can't refer to headings as an aid to construction, which seems a bit odd. You could have a clause which says there should be no presumption that clear words are required to depart from the common law position. And that would then be a guide to both the reader and the court or a tribunal in construing the contract. I mean, if there is a as we say there is a clear words principle, then self-evidently by sufficiently clear words, the parties could, I was going to say derogate again, but differ or depart from that common law position. As I say, if they do so expressly.
I think the difficulty I have with what you've been saying, although I sympathise with the argument, because I think you're basically saying the common law of contract applies, and that is the background against which all contracts are made.
Yes.
It's just invoking the clear words principle, because the clear words principle denotes a particularly high degree of clarity. And when we've got an exclusion of rights or a taking away of rights or remedies, you can understand that, because it's unlikely that a party would wish to have their rights taken away in this way. But I'm not sure you can flick over to say, well, it's the same degree of clarity that applies on the other side of the line, where you are conferring additional rights, because there's no reason, there's no unfairness or anything of that kind. It wouldn't seem so bizarre that people would agree to this. So that what you end up with, I think, is the proposition I'm going to put to you, is if there is a presumption at all, it's extremely weak. The degree of clarity is nothing like as strong as you would need if you were, for example, taking away somebody's rights. Well, there may be a view that if you're departing, we want to see words that, okay, make clear that you're departing.
Yeah.
But I don't think it's the sort of high degree of clarity that a so-called clear words principle is really driving at. Am I wrong with that?
Yes. I say with the greatest respect, but yes, you are. Because you're looking at it only from the perspective of the party who is being gifted the right. The corollary of gifting the right to in this case, the buyer.
Is the word gifting an apt word?
Well, creating. Or,
both parties agree.
It creates a right. In addition to creating the right for the buyer, you are the same clause is imposing a very substantial obligation on the seller. It is imposing the obligation on the seller to pay substantial damages for loss of bargain in circumstances where, at common law, he would not be liable to pay damages for loss of bargain because he was not guilty of any repudiatory or renunciatory breach. And if the high standard of clarity is required to take away rights, we would say by exact analogy, the high standard of clarity is required to impose obligations on, in this case, the buyer.
But is that right? The essence of most contracts is that in various different places, one party is conferring rights on the other party. And the general principle of construction is to take a fairly fulsome view of what they have done by the words that they have used, not an excessive view, but certainly not a restrictive, oh, well, you only do anything, you only give anything to the other side if you do it by clear words. That would seem to me to run against some pretty deep-seated principles of interpretation.
Well, one can see in relation to, if you like, the primary obligations on each side. What we're looking at here, though, is, if you like, the sort of the secondary framework, the framework of rights and obligations that apply, for example, in the case of breach. And we say, as I said in response to Lord Burrows, the position at common law is that if you are not guilty of repudiatory or renunciatory breach, you are not liable to pay loss of bargain damages. A clause which purports to make you liable to do so, where you are not in repudiatory breach, where your conduct is not such as to deprive the other party of substantially the whole benefit of the contract, where your conduct does not go to the root of the contract, where your conduct is, as a matter of common law, not treated as being the cause of the loss of bargain. It is a radical departure from the common law, a substantial extra imposition and obligation to require you to pay loss of bargain damages. And in those circumstances, we say it is entirely consistent with a clear words principle, with the analysis of contracting against a framework of rights and obligations expressly discussed by Lord Leggett in his judgment in Triple Point, to say that clear words are required to achieve that departure.
Of course, ultimately, you're agreeing that it's the construction of the particular clause that we're going to have to turn to.
Yes.
I mean, you're putting us in the framework that we're going to have to find extremely clear words. Okay, but ultimately it's going to turn on that construction.
Yes. I mean, ultimately, you have to look at the clause in the particular contract, in the setting of the contract as a whole, and you have to decide whether, on a proper construction of that clause, it is sufficiently clear or not. We do not say that it is impossible to create a right to loss of bargain damages where there is no repudiatory breach.
I mean, it's quite significant, it might be said against you, that none of the books, as far as I can see, on interpretation, use the clear words principle to cover the sort of situation that you are asking it as to accept it covers. It certainly deals with taking away rights. So Lewison and McNeill, there's nothing in Chitty that links Noverson or anything of that kind. That seems a bit surprising if it's such a well-established principle.
Well, I fully accept that the books tend to look at it from the perspective of the taking away of rights. But in my submission, where you are imposing an obligation, disadvantaging a party by the imposition of an obligation, particularly an obligation which goes far beyond what the position would be at common law, that is no different from the removal of rights position. And I mean, Lewison, which is cited by my learned friend, says that a clear words.
Which paragraph?
Oh, I'm afraid I don't have the paragraph reference immediately to hand. He says that Lewison says that a clear words principle is underpinned by considerations of unjustness. But we say that that is directly applicable in our case, because it is, given that there is a very well-established common law principle that a non-repudiatory breach does not sound in loss of bargain damages, there is that where there is a contractual termination following a breach that is not repudiatory, the breach is not treated as being the cause of the loss of bargain. There is an injustice, a lack of justice, an unjustness in imposing an obligation to pay loss of bargain damages.
Even if on the proper construction of the contract, that's exactly what they agreed to do. They agreed to do. Is that unjust?
Well, the point is that because, as a starting point, it is unjust to require a party that has not caused the loss of bargain to have to pay loss of bargain damages. That's why you have to have clear words in the express compensation clause to create that obligation to pay loss of bargain damages absent a repudiatory breach. I mean, if one says, with the greatest respect, Lord, if one says that's what they've agreed to do, that's begging the question whether the clause is sufficiently clear to impose that obligation to pay loss of bargain damages or not.
We've probably already touched on this, and I'm sure you're going to come to it, but could I just be absolutely clear what you say the clause does cover? If it doesn't cover loss of bargain, you say it covers expenses and interest, and then you said, what were you saying, loss of profit for the...
Loss covers loss delay. The clause imposes an obligation to be ready to deliver on time. And if there is a breach of that obligation, such that delivery is late, then the seller has to compensate the buyer for any loss caused by the delay. And that may be very substantial. I mean, in this case, the buyers were awarded $1.65 million pursuant to Clause 14b in respect of the first period of proven negligence.
So what's the loss if there's a failure to provide the vessel on, say, the first of the month, and on the same day the buyer operates its right to cancel the contract? What's the loss there? On the same day. So on that occasion, what loss do you envisage?
Well, in that case, there will be no loss for delay because there has been no loss for delay.
Right.
The second part of the clause then provides that the buyer will be entitled to recover all expenses.
Right.
We say that all expenses is wide enough to encompass wasted expenses and reliance losses. But one could ask another question.
No, just make sure I fully understand. There would be no losses in such a circumstance.
There would be no loss for delay, yes. There would be no
and you can't envisage any other loss?
Well, the clause still allows recovery for the expenses.
Yep. But I'm looking at the word loss.
Yes, exactly.
No other loss.
Correct.
No loss.
Correct.
Okay.
But by the same, I'm so sorry.
I mean, if there's cancellation and there's no delivery, so why are we looking at loss arising out of delayed delivery?
Because the breach of the clause, the breach of the readiness obligation, is not non-delivery. The breach of the obligation results in delay, results in the seller being late. What causes the non-delivery in the case of a non-repudiatory breach is simply the buyer's exercise of the right to cancel. And then that's really the essence of the case. Where it is the buyer's election to cancel that causes the loss of the bargain, why should sellers have to pay loss of bargain compensation.
It could be said against you that 14B expressly contemplates recovery for some loss, even if the buyers do cancel. Unless you interpret the last "and whether or not" part of the sentence as only applying to expenses. But it's not, I think, an easy reading of the clause.
Well, I was addressing Lord Stephen.
Well, I know, but I'm picking that up and saying, yes, I think you more or less conceded to my lord that if the buyer cancels by the expected delivery date, the notice date, notice of readiness date, he won't be able to recover any loss on your case from delay,
yes,
nor any other kind of loss that you can envisage. But it could be said that the words of clause 14b expressly contemplate that there may indeed be loss in that situation.
But so the position that was being put to me is the very narrow one of cancellation on the very same day.
Well, it's got to be quite soon after.
It may have to be quite soon.
How long have you got to cancel after if they're not ready if they don't serve notice of readiness for the road?
There's no express time limiting the right to cancel.
But there's always a risk that you will have affirmed if
yes.
you don't cancel fairly.
There's a risk.
A fairly swift cancellation.
Yes.
Therefore, a narrow period of existing life of the contract where you're going to cancel is a fairly typical way of looking and seeing how this works.
Yes, and in those circumstances, the quantum of the loss is likely to be small. By the same token, if the market has fallen, and the buyer cancels, then he suffers no market loss. What is the loss then? On that different factual scenario, answer: no loss. One can posit different factual situations in which there is substantial loss. One can posit different factual situations where there is... Well, one can posit situations where there is factual situations where there's loss and factual situations where there is no loss. The fact that there are some factual situations that one can posit.
But I think your case is that where there is a prompt cancellation, there can never actually be any loss because all the delay lies in the future and you can't think of any other kind of loss that would fit the bill. So it's nothing to do with whether the market's risen or fallen or whatever the other circumstances are. There just can't be any loss.
No, well, as a matter of principle, if there's a short period of delay, there can be compensation for that period of delay. But, I mean...
Okay.
So I'm having a little bit of difficulty getting my head around the short period of delay. Say, for instance, the one day delay. In the real world, what possible charter party could you possibly enter into for the or use of the vehicle of the vessel?
Well, one possible sanario would be if the buyer had already entered into a fixture for the vessel and was put in breach of that even by a short period of delay. It's possible to posit cases where delay causes substantial loss. But in my submission, it's not a particularly helpful approach to construing the contract to ask what is the quantum of the loss going to be in different circumstances. As I say, if one posits a falling market, then even on Malaire Friend's case, there is no loss. So it's not a helpful guide to construction to say, in this factual situation, there wouldn't be any loss, would there?
But the difficulty, I think, that you face is that due compensation to the buyers for their loss. Let's just assume that means factual loss. There wouldn't be any factual loss if the market goes the other way. But there is a factual loss here.
Yes.
They have lost. factually. So how do you read, shall make due compensation to the buyers for their loss? What are you saying? Except where that loss is not recoverable at common law.
Well, it's loss which has been caused by the breach, not loss which has been caused by the buyer's exercise of their right to cancel. And we say this is the critical error in the Court of Appeal's judgment, because essentially Lord Justice Nuji adopted that line of reasoning that, as a matter of fact, they have suffered a loss, therefore that loss is recoverable. And
but if, as a matter of fact, if we're entering into a contract and we're thinking about, well, what are our losses going to be, you would expect the parties, just as a starting point, to think, well, we're entitled to recover our factual loss as a result of what you've done. That might be the starting point. You wouldn't expect to recover where you've not suffered factually the loss. So that's the starting point. And then you say, but you've got to put into that there's sort of legally recoverable loss. That they're actually, when they use that clause, they want to say, provided it's recoverable at common law. That's in effect what you're requiring us to read into the clause, isn't it?
No, because the misstep there is to say they're entitled to recover their factual loss because of what you've done. They haven't suffered the factual loss because of what the sellers have done.
You say that's factual causation, do you?
No, it's a principle of law that where there is no repudiatory breach, the non-repudiatory breach does not cause the loss.
Well, I think,
and it's counterintuitive in my submission to construe a clause which says compensation for their loss as compensation for a loss which has not been caused by the breach.
Which has not been legally caused, although factually caused. I mean, it amounts to the same thing. You're saying not recoverable as a matter of law. Now, your justification for that is because the law has a rule on causation.
Yes.
But I was putting to you that if you're looking at it as a matter of fact, this clause covers what's happened here. So we have to somehow, on your submission, get to the view that it's not what's factually happened or was going to happen, but as a matter of law.
Well, as a matter of fact, in fact, the breach is irrelevant. As a matter of fact, it's the mere lateness itself which triggers the right to terminate. Buyers can as a matter of fact, buyers can terminate whether or not there's any breach.
Yes, but the contract, doesn't go so far as saying you can recover loss of bargain in it.
It doesn't in those circumstances, yes.
It's qualified by saying yes, but you only get loss, any kind of loss,
if there's a breach.
If there is negligence.
Yes,
that's right. In other words, a failure of the best endeavours obligation to be ready in time.
Yes. But
you accept that factual causation would be satisfied here?
Well, the factual causation is in the award, so I can't go behind that. The question, again, it comes down to the question is whether, as a matter of construction, this clause is sufficient to create a right to recover loss of bargain damages in circumstances where the law, as a matter of law, the breach is not treated as causing the loss of bargain.
And why not? Why shouldn't that be the case? I mean, you're saying, well, it covers delay. So that, some people might call that incidentally. It seems to me there is a terminological problem here because some people might call that loss of bargain. If you receive something late, you're entitled to the bargain that you were entitled to. But let's leave that terminological quibble to one side. why should people be agreeing to delay loss, but not what we're terming loss of bargain? Well, why should they agree to that?
Because of the principles of legal causation. The breach, which results in late delivery, is undoubtedly, as a matter of law, the cause of the delay losses. But as a matter of law, a non-repudiatory breach is not the cause of the loss of bargain. The cause of the loss of bargain is the buyer's election to terminate. And in our submission, it requires very clear words that are not here in this clause to create a right to compensation in respect of a loss which, as a matter of law, has not been caused by the breach. I mean, that is, it's a very radical, and we would say prima facie unjust result, that a party is held liable for a loss which, as a matter of law, it has not caused.
Can I just be absolutely clear that the proposition that this is not caused as a matter of law, you're going back to those authorities I think you gave me earlier. You're saying it's
yes.
Financings and
costs.
Yes, and costs,
yeah.
and so you say that that's not in dispute.
Yes, it shouldn't be. Yes, yeah.
Right. I mean, the other side, of course, may say,
well, they have their
tenuous anyway.
They have their respondent's notice point, which are perhaps convenient to deal with that very briefly now.
Okay.
They have their.
Are you making anything of the words due compensation?
We do. I mean, we say that I think it's common ground that due compensation means appropriate or fair compensation, and that feeds into our argument that it is not due or fair or appropriate to award compensation for losses which are not caused by the breach as a matter of law. The word due doesn't appear in clause 13, and I don't wish to rely too heavily on that difference in wording between 13 and 14, because these contracts are not an exhibit of model drafting where one can assume that every word has been chosen with a very specific reason and purpose in mind. But notwithstanding that, due does appear in 14, and it, as I say, I think it's common ground that it means appropriate or fair in all the circumstances. And it is not due compensation to require payment of loss of bargain damages in circumstances where the breach has not caused the loss of bargain as a matter of law.
And why do you say that the Sale of Goods Act isn't a straightforward answer to the legal position? Why isn't this covered by non-delivery of a ship?
Because it's not a case of non-delivery. The breach doesn't cause, unless there is a repudiatory or renunciatory breach, the breach of the readiness obligation, the failure to be ready on time, isn't a case of non-delivery. The legal cause of the non-delivery is the exercise of the option.
It's back to the same point, really.
Yes. I mean, our case is a very simple one.
I mean, has the case been put this way at any stage before?
Yes, it was. Yes, I mean the essence of it in the Court of Appeal is the same as reliance on the financing principle.
Yes, but in terms of legal causation.
I'm not sure if it was put in exactly the same way. I mean, I certainly remember some months ago reading the skeleton argument for the Court of Appeal and not considering that the way in which I intended to argue the case was a radical departure from the way in which it had been put in the skeleton argument. I mean, even if I put the argument somewhat differently from the way in which it was put below, and invite your lordship to deal with the argument as I put it.
Well, Mr. Russell, we've been barraging you with questions, and I can see the time ticking away. I don't want to prevent you from going into areas which you have yet to.
Yes. Well,
and I imagine, for example, you may want to say something slightly more detailed about some of the authorities. I don't know, although a lot of them are.
Yes. I mean, I think if I look at my notes, I'm probably on page 1.
Well, that's what I slightly feared.
I suspect I'm going to have to do some trimming. What I was going
to say that it's been very helpful for us that we've had this very free-ranging.
Well, I mean,
that's what we're here for.
Absolutely, and it's obviously much more helpful for me to know the troubling the court rather than just reading through my notes in icy silence. So I'm equally very grateful for the opportunity to deal directly with the court's concerns. What I was going to do, probably about half an hour ago in response to Lord Stephen's comment or question, was look at one specific aspect of what we call the clear words principle. Because one might say that there is a wide principle, which is the one that we've been exploring so far in relation particularly to the passage in Triple Point. But specifically in relation to conditions, there is what one might call a narrower clear words position. Just bear with me a moment. And so there are a couple of stages to this submission. It is well established, we say, that a contract has to make it clear that a term is to be construed as a condition rather than an innominate term. There is if you like,
Yes, you did mention that first time round, although you ran past it quite quickly.
I would say I was diverted from it rather than running past it. I want to come back to that and show you the authority in relation to that. And we say that's important in this case because, I mean, certainly there are two effects that classification of a term as a condition has. First is that any breach gives the innocent party the right to terminate. And second, any breach of a condition gives the innocent party the right to claim loss of bargain damages if they do terminate. As I say, I'll show you the Spark Appellant, which makes it clear in the Court of Appeal that the contract needs to make it clear and to be clear words to construe a term as a condition rather than an innominate term. Now, this clause, 14A, has the effect, it actually goes beyond making the readiness obligation a condition, in that it provides an express right to terminate when there is lateness, whether or not there is a breach of the readiness obligation. And 14A does that in clear terms. The effect of 14B, if my learned friend is right, is that it in effect turns for, the readiness obligation into a condition in relation to loss of bargain damages as well. Because on my learned friend's case, any breach of the readiness obligation will sound in loss of bargain damages. However serious, however trivial, whatever the consequences, whether the consequences are serious or trivial. And just as clear words are required to construe a clause as a condition, so we would say on this narrow version of the clear words principle, clear words are required to have the effect of turning a clause into a condition for the purposes of recovery of loss of bargain damages.
I mean, is there any case where that distinction's been made? Generally speaking, a clause which either does or doesn't impose a condition may have to have a certain clarity as to that it does, without going on and saying, and by the way, if you're in breach of it, I can recover loss and bargain damages. I mean, that just follows as a matter of law without having to spell it out, doesn't it?
Oh, absolutely. Sorry.
I think you're saying there are two elements to the clarity required. One is the clarity that has the conditional effect as enabling termination to take place for any breach.
Yes.
And it must clearly prescribe loss of bargain damages.
No, I'm sorry. No,
I may have misunderstood.
I haven't made myself clear.
I'm sorry.
The position at law is that for a contract to be construed as for a clause to be construed as a condition and not an innominate term, clear words are required.
Yeah.
If the contract clearly makes the term a condition and not an innominate term, then the inevitable consequence is that loss of bargain damages flow from any breach. It's not necessary. I don't suggest that in the context of a clause which is construed as a condition, there is some further hurdle that requires wording making it clear that loss of bargain damages will be payable, because it is inherent in the nature of a condition that the parties are taken to have agreed that loss of bargain damages will be payable in the result of any breach of the condition. That is in the nature of the condition itself. What I say is that where a clause is not a condition and is just an innominate term, which the readiness obligation is, then if it is to be treated analogously to a condition, in that any breach is said to sound in loss of bargain damages, there have to be clear words to that effect.
Is there any authority to that effect? No.
Well,
being treated as analogous to a condition in one respect, not in every respect.
We haven't found any authority that is directly on point, but we say it must be the same principle or a principle very closely analogous to the principle that clear words are required to make a clause a condition.
Well,
so,
I think Lord Justice Newty identified the provision in a contract for the sale of land enabling a purchaser to make time of the essence if his vendor was delaying, such that any further delay
yes,
automatically enabled the purchaser to walk away from the contract, get
yes,
his deposit back, and I assume claim for loss of bargain, without that having to be spelt out. Now that sort of clause isn't, I think, within what everybody seems to regard as a condition in this because it's not there from the beginning and it's not automatic.
No, exactly. I mean, it's a separate line of authority.
But it's quite like this, because here the buyer can can in fact even retrospectively say, well, you didn't serve your notice by the relevant date, and even though that was only because of a breach of a best endeavours obligation, I can terminate, even if you're 12 hours late.
Yes, exactly. I mean, here, the right to terminate is created whether or not there's a breach. I mean, that part goes beyond that.
It's an option to turn something into a condition. Even if everybody seems to agree it's not quite a condition. Yeah, I may be misrepresenting your opponent's position. You may say it is a condition, but I think it seems to be common ground that it's not a condition as such.
It is common ground that it's
Yes,
not a
I thought
condition.
so.
It's an anominate term.
Yes.
This case is different. I mean, I must say that line of authority on making time of the essence when it isn't otherwise of the essence, I've always find a rather curious proposition. But this is not that case in any event.
Not quite.
Well, in my submission, not really at all, because what it does, it's in two parts, and the two parts are quite distinct. So the first part creates the express right to terminate in the event of any lateness. And that's there from the start. Yeah. It's baked into the contract. And the second part is the creation of a right to compensation where there is a breach of the anominate term. And the point that I'm making here is that just as clear words are required for the construction of an anominate term as a condition, so clear words should be required to achieve the result that any breach of the anominate term sounds in loss of bargain damages. I'm going to say it again, even where, as a matter of law, the breach hasn't caused the loss of the bargain. It is the exercise of the 14A option that has caused the loss of the bargain. I mean, just in relation to the point that clear words are required before a contract will be construed as a condition.
This is really just an amplification of your clear words principle, though, isn't it? Mm. If you write on your clear words principle, you don't really need another analogy, which might or might not be problematic, because you're having to split up the consequences of conditions. I mean, you've either got enough already, haven't you, without this additional point?
Well, it depends how you look at it. If I'm right on the broader principle, then yes, I've got enough already.
This is an alternative string to your bow.
This is
an alternative way of getting to the clear words principle.
It's a narrower clear words principle because even if you're against me on the broader clear words principle, in the context of a clause which has the effect of turning an innominate term into a condition, because the result of the clause is to create a right to loss of bargain compensation for any breach, whether repudiatory or not, then clear words are required to do that. So the decision in the Court of Appeal in Spark Appellant is at page 748. It's tab 27, bookmark 27. And in the judgment of Lord Justice Gross at paragraph 52.3, that's page 759. At 52.2, Lord Justice Gross says, secondly, Lord Scarman said that on a true construction of the contract, the parties have not made a particular term a condition, and if the breach of that term may result in trivial, minor, or very grave consequences, then the term is innominate. So thirdly, Lord Wilberforce, Lord Scarman, and Lord Roskill, unless the contract made it clear that a particular stipulation was a condition or only a warranty, it was to be treated as innominate, an innominate term. The courts should not be too ready to interpret contractual clauses as conditions. And one might ask, well, why not? And the answer is because they obviously have draconian consequences. And the same can be said of the construction proposed by learned friend adopted by the Court of Appeal in this case, that construing 14b as giving rise to a right to loss of bargain damages, even where there is no repudiatory breach, is a draconian consequence because, again, as I have said and continue to say, it creates a right in respect to compensation in respect of a loss of bargain that is not caused by the breach. And there are passages to the same effect in the judgment of Lord Hamblin at page 767 of the bundle. Paragraph 92. The modern English approach to the classification of contractual terms is that a term is innominate unless it is clear that it is intended to be a condition or a warranty. And in the judgment of the Master of the Rolls at 768, paragraph 99, is essentially a reference back to the paragraphs that I've already shown you.
Yes, it's quite difficult to apply Master Rolls' analysis to a contract which, in fact, enables the buyer to terminate without there being a breach at all. So you can't get much more draconian than that.
Correct. But that right is clearly established by 14A.
Yeah, absolutely. It's a tough world in which the seller is living under this contract on any view. I mean, bearing in mind the exigencies of life, which sometimes means your ship's not ready on time.
Yes, well, I mean, this is the... I mean, if one thinks of it in terms of allocation of risk, which is perhaps maybe a helpful way of looking at it, there are all sorts of reasons why a ship might be late, why a ship may not be ready for delivery by the cancellation date. Some may be the fault of the seller, and some may not be the fault of the seller. And what this clause does, so that the first layer of allocation of risk is allocates risk of lateness to the seller in the sense that any lateness gives the buyer a right to cancel. There is then a narrower allocation of the risk of consequences of lateness in 14b, in which we say provides that if there is a breach, but a non-repudiatory breach, then there is a liability for loss and expenses, wasted expenses, but not for the loss of bargain, unless the breach is repudiatory or renunciatory, such that as a matter of law, it is viewed as and treated as causing the loss of bargain. And that is a sensibly calibrated allocation of risk, a tiered allocation of risk, if you will.
It seems to me that when one's talking about the clarity needed in order to have a condition rather than an innominate term, none of the judges are thinking about the secondary consequence. They're actually thinking, surely, about can you terminate for just breach of that term or not? That, I think, is the clarity that they're saying there needs to be. And the idea that they would be thinking, oh, well, that links in then to whether you can get loss of bargain damages strikes me as a bit far-fetched on the face of it.
Well, in the context of a long-time time charter, which is the context of the Star Capella, if the the right to terminate is treated as being a condition, the loss of bargain can be huge. So the secondary consequence, the right to recover loss of bargain damages in the context of a long-term time charter party is of very great significance. Really, I mean that's it's the whole. I mean it's the essence of the decision in the Spark Appellant, which is that. So bear in mind that the Spark Appellant there is a contractual right of withdrawal, which is whether or not it's treated as a condition. So it really, I think that in the Spark Appellant, it is the secondary obligation is the critical question, whether on exercise of the right to withdraw for non-payment of hire, the right to recover loss of bargain damages arises or not.
If you look, for example, at the Master of the Rolls, paragraphs 98 and 99, page 768.
Yes.
He makes it absolutely clear that what he's whether the time payment stipulation was such or a warranty sounding only in damages, as opposed to being able to terminate, that's what the question is about. That's why you need the clarity. Inherently unlikely, he says in paragraph 99, that contractor would wish to confer on them a right to treat the contract as an end for breach of a term, maybe broken in different ways. They're not thinking about the quantum of damages.
Well, as I say, where there's no doubt that there's a right to terminate under the withdrawal clause, I mean, the point of the issue in the Star Capella, whether it's a condition or not, is does the exercise of the right sound in loss of bargain damages or not? And that's what the issue in the case really is.
The issue was basically defined at page 750, paragraph 1. And we don't have the what rights are available under the when the ship is withdrawn from service.
Well, if one looks at paragraph 1, is charterer's failure to pay an instalment a breach of a condition strictly so called,
Yeah.
or without more does such a failure merely entitle ship owners to withdraw? So in either event, they're entitled to withdraw. Yeah. The point is that if it is...
well, insofar as I understand the answer to the first question, no, it's not.
Yes.
The answer to the second question, as yet I haven't read through this, so I don't know what the answer to the second question was.
Well, it's the same question. The two parts of the same question. The answer is it's not a condition. It merely entitles the ship owners to withdraw.
But does the withdrawal right give a right to due compensation of expenses? No. Well, there we are. It's different.
Yes, I mean it is right that the case does not. It's not on all fours by any stretch of the imagination, because it has an express termination clause, the withdrawal clause, but does not have, in addition, the express compensation clause in 14b. But it is, in my submission, not irrelevant, because the same factors apply in both cases. If you construe the withdrawal clause as a condition, the consequence is a right to recover loss of bargain damages. Here, we have an express compensation clause. The question is, as a matter of construction of that clause, does it sound in loss of bargain damages, even where there's been no repudiatory breach, and therefore the cause of the loss of bargain is not the breach. The cause of the loss of bargain is the election to terminate. Right. Well, Lords, we've given you the references in our skeleton argument to the relevant passages in the authorities that deal with both principles on which we rely. What I'd like to do, given the limited amount of time that I have, is first to address a number of points in relation to both the contract as a whole, and particularly the what is said to be a balance between clauses 13 and 14, and also touch on some of the supposed commercial considerations. And my learned friend says that if we go back to the contract, which is at, as I say, it starts at 1253 in the bundle. And we have clause 13 at page 1260. And clause 14, obviously, at 1261. My learned friend submits that his construction creates a balance between clauses 13 and 14, and that in some way supports his construction. This is an argument that also found favour in the Court of Appeal. But actually, if one looks at, well, superficially, they look rather similar, being headed buyer's default and seller's default. In fact, they are really very different clauses indeed. Looking at clause 13, the first part of 13 deals with payment of the deposit. And of course, what is important to remember is that in relation to the payment of the deposit, the underlying obligation is a condition, so that any breach is repudiatory. And then, if one looks at the second part of the clause, this provides that if the sellers have a right to cancel if the purchase price isn't paid on time. And in those circumstances, the sellers have the right to the release of the deposit. So the primary remedy that is given to the sellers under the second part, well, let's start again. Under the first part, they have a right to claim the deposit. That's the decision in the Griffin. And under the second part, they have a right to retain the deposit, even if that is greater than their actual losses. You'll note also that clause 13 is only addressing the situation where sellers do cancel. There's no equivalent wording that we see in 14b in relation to the clause applying whether or not the buyers cancel.
Just to be clear, do you accept that in both limbs of 13, loss of bargain is included within losses?
It is in relation to the first limb because the obligation to pay the deposit is a condition. In relation to the second limb, the obligation to make payment, in relation to that, prima facie pursuant to 10(1) of the Sale of Goods Act, the obligation to pay is not a condition, it's an innominate term. And consistently with my argument on 14b, we would say that the obligation to pay further compensation for their losses only arises if the failure to pay the purchase price is repudiatory or renunciatory. But obviously what clause 13, the second part of 13 does is, as I say, give rise to a right to retain the deposit regardless of losses incurred. So the regimes, the two regimes, in that sense, the clause 13b in particular is something of a departure from the compensatory principle, but is achieved by very clear words.
But the language of the identification of loss is pretty well identical in both limbs.
Yes, but I agree with that, and that's why I say if the failure to pay the purchase price is treated as being a breach of an innominate term, you don't get compensation for losses if they are higher than the deposit, unless the breach is repudiatory. But what 13b does is create, using clear words, create, if you like, a freestanding right to retain the deposit.
Well, not just to retain the deposit, but to get compensation on top. If the deposit is insufficient to cover the loss.
Yes.
It's difficult to think of anything other than loss of bargain that would overtop the deposit.
Well, indeed, but we say it only if the breach is repudiatory. Because, again, one comes back to construing compensation for their losses as being loss caused by the breach. One needs very clear words, we say, to create a situation where there is compensation to be paid for losses that are not caused by the breach. So
would you accept that if 13b did cover loss of bargain in a non-repudiatory breach situation, that would be an absolute knockout of your argument on 14? Or would you then say, oh, well, they're just different? I mean, are you saying anything turns on the particular wording of compensation for their losses, which is obviously and for all expenses incurred together with interest? Are you saying that that's essentially the same as 14 and they stand or fall together?
Yes, I accept that because I mean, there's a difference in wording. Because 13b is further compensation for their losses, whereas 14b is due compensation for their loss. Now, one can't read anything into the difference in my submission between losses and loss. It's simply an example of somewhat careless drafting. One could, in theory, seek to construct an argument that due compensation is different from further compensation. But I would accept that it would be asking the word due to do too much heavy lifting to support an argument that there is a material difference between the two. The right answer is that if the obligation to pay the purchase price is viewed as an innominate term, in both cases, loss of bargain damages are only available if the breach is repudiatory. Where the position would be different is if the obligation to pay the purchase price is construed as a condition. Because in that case, clearly, loss of bargain damages would flow from any breach.
So you're saying that they're consistent?
Yes. Now, I want to make one submission in relation to the commercial consequences of the rival constructions. And that is to consider the position that a buyer is in if faced with lateness. And we say, if one looks at it from the position of the buyer faced with lateness, there is a very significant commercial benefit in our construction. So assume that the sellers are late, they're not ready by the cancelling date. As we've seen, there's no doubt that that gives buyers an unfettered right to cancel C14A, not dependent on whether sellers are in breach or not. Assume that the market has risen, as it had in this case. Before exercising their right to cancel, buyers are likely to want to know whether or not they'll recover the market loss for loss of bargain if they do cancel. Clearly, there will be maybe a greater incentive to cancel if they know that they are likely to get loss of bargain damages than if they don't. On the buyer's case, they will only get loss of bargain compensation if the lateness is due to sellers' proven negligence. So the question that the buyers ask themselves in determining whether they are likely to get loss of bargain compensation on the buyer's case is, were the sellers negligent? Have the sellers failed to exercise due diligence to be ready? On our case, the question that the that the buyers have to ask themselves to determine whether they get loss of bargain damages or not is, were the sellers in repudiatory or renunciatory breach or not? Now, it's likely that in many cases, indeed most cases, it's going to be very difficult, if not impossible, for buyers to know if the lateness was due to the seller's negligence, seller's want of due diligence or not. It's going to depend, obviously, on the facts, highly fact-specific, and highly likely that prior to disclosure and witness statements, most of the relevant information is known only to buyers. And realistically, in many or most cases, buyers on their own case are not going to be able to assess at the time of exercising their option whether they are going to be able to recover loss of bargain damages or not, because it will be impossible for them to make a reasonably informed decision as to whether they will be able to establish negligence or not. By contrast, in our case, although the right to recover arises in narrower circumstances, it is much easier for sellers, I beg your pardon, it's much easier for buyers to assess whether prior to exercising their option, sellers are likely to be held to have been in repudiatory or renunciatory breach. Given that the breach is failure to be ready on time, and that gives rise to delay, as we have said in the skeleton argument, it's unlikely that delay itself is going to meet the threshold for repudiatory breach, substantially depriving the buyers of the benefit, or depriving the buyers of substantially the whole benefit of the contract. And all one has to do, really, is look at the period of delay. One can ask lawyers whether that period of delay is likely to be held long enough to constitute a repudiatory breach or not. And in relation to a renunciatory breach, which is the more likely route in our submission towards recovery of loss of bargain damages under 14b, the sellers have to have evinced an intention not to perform. But that is going to depend on their communications with the buyers, or their conduct of which buyers are aware. And so our argument is more commercial, as I say, in the sense that it enables buyers to make a much more informed assessment as to whether they're likely to get loss of bargain damages or not. And there's no uncommercial. There's a separate point. There's no uncommerciality in sellers getting the benefit from the increase in the market in circumstances where buyers have chosen to terminate. I mean, that is simply a feature of buyers having the option to terminate. In our case, the clause strikes a balance. It is a perfectly fair and sensible balance in commercial terms. If the buyers choose to exercise their option to terminate, notwithstanding the fact that the market has risen.
Doesn't deal with the limping contract where the market has risen, where the buyers want out, they're not prepared to hang around forever. But on your approach, they wouldn't be in a position to.
Well, if there is a continuing failure to deliver, if sellers say we're going to be ready next week and they're not ready, and your buyers give them another chance, sellers still not ready, buyers give them another chance, it obviously would depend on the facts, but in those circumstances it would be unlikely that, in my submission, that a tribunal would hold that buyers had lost the right to terminate. They would still have the right to terminate, and they would be able to claim the damages for the delay in the period during which the non-delivery took place, the failure to deliver took place. And one has to remember, I mean, it's one of the themes of Malher Feren's argument is that he in looking at commercial consequences, he repeatedly contrasts the position of what he labels the innocent buyer with what he labels the negligent seller. It's, in my submission, that is a false dichotomy, or at least not the relevant dichotomy. And the reason for that, again, goes back to the common law position that mere breach of contract doesn't create a right to terminate. the buyers only have a right to terminate in this case because the contract gives them that right to terminate under 14A, unless, of course, there is a repudiatory or renunciatory breach. Now,
which is itself a big jump out of the common law framework.
It is. But it lies ill in the mouth of the buyers who have been granted that additional right to terminate, to effectively say, well, it's not fair if I don't exercise that right. I'm faced with a dilemma, because if I don't exercise that right, either I'm stuck with my negligent sellers if I want to take advantage of the rising market, or I don't want to be stuck with my negligent sellers, so I terminate, and I'm not entitled to loss of bargain damages unless I establish a repudiatory or renunciatory breach. I mean, essentially, what he's saying is, because I've been given this additional express contractual right to terminate, it should follow that I get loss of bargain damages as well. Otherwise, I'm put in this difficult position where I won't get my loss of bargain unless I stick with the negligent sellers. But I'd say that's seeking to rely on the creation of one right to create a separate and wholly different right is definitely analogous to turning it has the same effect as turning what it is agreed in common ground is an innominate term into a condition. Lord, as I say, we have set out the references in the written case to the passages in the cases like financings and the costs and so forth. We've also set out the cases that we rely on in relation to the clear words presumption. I'm pretty much at the end of my 2 hours, so rather than sort of taking to half of a case, what I propose to do is save my time for reply and pick up on any points that my learned friend makes in reply.
Yes.
Just to be clear, do you rely, and if so, how, on the reasoning of Mr. Justice Dias?
I mean, yes, we say her analysis is right, and in particular, the analysis that the nature of the breach is one that goes to delayed delivery, not non-delivery. The critical error that the Court of Appeal made, that Mrs. Justice Dias did not make, is to treat the seller's failure to be ready on time as a failure to deliver at all. In other words, to equate the failure to be ready on time with a case of non-delivery. That's really the critical point of distinction between the first instance judgment and the Court of Appeal judgment. And again, it comes back to the point established by financing and the other authorities. The reason why this is not a case of non-delivery is because the effective cause in law of the fact that the vessel is not delivered is not the breach, it's the exercise of the option. As I say, that is the fundamental flaw in the Court of Appeal's analysis. It's the fundamental flaw in their friend's analysis.
Well, thank you. This clock may be a minute fast, but I think you've got that.
Thank you.
Yes, Mr. Lewis.
Good afternoon. Subject to any questions, my structure will be sixfold. First, I will outline what this case is and is not about. Excuse me. Secondly, I will take my lords through the MOA, identifying in particular where buyer costs or expenses are liable to occur in the performance of the MOA. Thirdly, address the ordinary and natural meaning of clause 14b, which we say covers loss of bargain, and if necessary, clearly does so. Fourthly, deal with the consequences of the competing interpretations, which strongly favour our case. Fifthly, address seller's clear words presumption. And sixthly, time permitting, deal with authorities on the NSF form, which all support our case. So to outline first what this case is and is not about, we say it's a straightforward question of interpretation of an express compensation remedy and how it applies following contractual cancellation. Three things, all of which give rise to difficult issues, reflect what this case is not about. First, subject only to our respondent's notice point, which Ms. Bond will deal with, it is not about whether loss of bargain damages can ever be recovered following cancellation under a bare cancellation clause. By bare, I mean one that does not have an accompanying express compensation remedy, either because there is none or because any express provision is unenforceable as a penalty. That was the issue in Financings and Baldock, the Australian AMEV case, Langille and Kenerick, the Canadian case, and it's the issue on which Canadian law has diverged from English and Australian law, as Ms. Bond will detail further. That issue also drove the attempt to argue for a condition in the Spark Appellant. It's also one focus of Professor Peel's termination paradox. But this case is different because of clause 14b, which is enforceable and means we are not dealing with a bare cancellation. If we only had 14a, all those authorities would be directly in point, but 14b sets the case apart. Secondly, this case is not about whether the claimant can recover more than the loss it has in fact suffered. That was the issue in Bungie and Nadera, Novison and Alimenta, and the Golden Victory. In this case, it is clear that the buyers did in fact suffer loss in the amount of the difference between the contract and market price. That is the indisputable finding of the tribunal. The different issue here is whether buyers cannot, as a matter of law, on the proper construction of 14b, recover that loss in fact suffered. Thirdly, this case is not about whether a party who terminated, citing ground A, can later rely on ground B, either to justify the termination or to claim damages, or both. That was the issue in Phones for You, in Dalkia Utilities and Celtec, Shell Egypt and Dana Gas, and Trademark Licensing and Leophilis. Here, the buyers were held by the tribunal to have cancelled under 14a and are claiming compensation under 14b. Distinct from those other cases, buyers are not here claiming compensation in reliance upon a basis other than the clause 14 cancellation that was upheld. So all of those...
Can you give me the third point again? I'm not entirely sure I understood it.
The third point is that there are a number of cases where a party who terminates does so on ground A, and then subsequently they say, we want to rely upon ground B. So, I mean, Boston Deep Sea Fisheries, they do it defensively.
Okay.
But in other cases, they do it more than defensively. They do it either to justify the termination as a platform or to claim damages specifically based on that termination. And so that covers those other cases I mentioned.
And is that because the 14b expressly contemplates it applying where there has been a termination under 14a?
Exactly. So we follow through the course of 14a. We are not, for example, in a case like Shell Egypt and Dana Gas, where reason given for termination was a contractual provision, clause 3.1.9, when they meant 3.1.8. But later they said, actually, we want you to find that we terminated for repudiatory breach and therefore can recover loss of bargain damages, which aren't there available under the contract. So all of those three different scenarios and the complex case law relating thereto, we say obscure that this is a straightforward case of interpretation of a standard form express compensation remedy. So on to my second subject. I want to take my lords through the MOA, identifying where buyer costs and expenses are liable to occur. And that will then inform our analysis of whether the remedies on seller's case are substantial in any way. The MOA is at page 1253, and we also have the standard form template at page 1177. The top right box on page 1253 shows how it is on sale form 2012, which is the latest revision of a form one sees originally adopted in 1956 and revised on the 5 occasions thereafter mentioned in that box. The first definition is banking days, which covers not only days on which banks are open in the country of currency of the price, but also in the price of closing. That's where the documents are to be exchanged for the payment as part of the documentary closing we'll see in a moment under clauses 3 and 8. There is also a definition for deposit holder, here identified as Hill Dickinson in Singapore, and that has costs implications, as we'll see in a moment. Clause 1 over the page, 1254, is the $15 million purchase price. Clause 2 covers the deposit. It's to be paid within 3 days of signing, and the deposit holder confirming that the account has been opened to receive the deposit. And then clause 2, at lines 40 and 41, provides for any fee, i.e. charged by the deposit holder for holding and releasing the deposit, to be borne equally by the parties. So that's a first category of expense incurred by buyers, namely their share of the cost of deposit arrangement. Clause 3 reflects the key reciprocal obligations and their timing. So we see on the standard wording after the first paragraph, on delivery of the vessel, but not later than 3 banking days after NOR under clause 5, the deposit is to be released and the balance of the price paid. Clause 4 deals with inspections, and as we saw with clause 16, here again the standard form offers 2 alternatives, A and B, to be deleted as applicable. One sees that suggestion at lines 73 to 74. Clause 4A, used here, applies where there's already been a documentary and physical inspection, whether by buyers themselves or a third-party inspection company such as IDWAL mentioned here. Clause 4B, which has been deleted but is more visible at page 1178, applies where there are to be prospective documentary and physical inspections after signing but before delivery. In either event, inspections are a clear second category of expense likely to be incurred by any buyer. Clause 5 on page 1255 deals with time and place of delivery and notices. And 5A at line 76 refers to the vessel being taken over. Whilst this does not explicitly refer to crew change, in practice it can mean that seller's crew disembarks and buyer's crew embarks at the point of physical delivery, handing over the keys to the ship, as it were. This aspect of the logistics was what led to the first phase of negligence in August 2021, whereby sellers failed to take reasonable care in arranging for disembarkation of their crew at Qingdao. And that's paragraph 26 of the Statement of Facts and Issues. Insofar as buyers have arranged an incoming crew that does not, in the event, board and take over the vessel at or around the cancelling date, that obviously has costs implications. So these crewing costs are a likely third category of expenses to be incurred by buyers. Clause 5A then at lines 78 and 79 effectively provides a delivery window, or at least a window for NOR, which we know then triggers a 3-day period for completion. So we have a not before date for the NOR at line 78, and then the cancelling date here, 20th of August, but that effectively became 15th October 2021. 5B is narrowing notices in order that the buyer can be primed to take over the vessel. 5C caters for the extension of the cancelling date, as happened here. 5D provides that buyer's decision in relation to a proposed new cancelling date is without prejudice to any claim for damages buyers may have under clause 14. Just pausing there, seller's case on the impact of the word damages here may have changed. In their written case, paragraph 13, that's page 16 of the bundle.
So page what, sorry?
16 of the bundle, paragraph 13 of seller's written case. Yep. They juxtapose it with the reference to due compensation in clause 14b, although where that point goes is not clear. Below, sellers said it was shorthand for sums payable under clause 14, and one sees that, for example, at paragraph 46 of the Court of Appeal on page 86. We agree with the latter proposition and say that the phrases are interchangeable. Clause 6 covers divers inspections and dry docking, which can, if they occur, lead to further inspection-related costs and expenses. And then if we move on to page 1258, please. Clause 8 deals with documentary closing, which is the office-based part of the completion of the transaction, simultaneous with the physical taking over on board the vessel. So in exchange for payment, as we see at clause 8a, the sellers provide delivery documents as either listed in the standard form or here by specific wording they were to be all reasonable documentation to be listed in an addendum. Clause 8e, so now we're pleased on page 1260, shows how concurrently with that exchange in the documentary office-based closing, there is also a document handover of keys, certificates and other documents, plans, etc. on board the vessel. So from outgoing crew to incoming crew. So all of this engages a fourth distinct category of expense, namely the costs incurred, which are likely to include, if not exclusively be, legal costs in preparation for and at the documentary closing. Clauses 13 and 14 are the key clauses, and we will come back to them in a moment. For this run-through, the last clause to mention is clause 15, which entitles buyers to place representatives on board between payment of the deposit and delivery of the vessel for familiarisation. That's on page 1261. On our facts, buyers tried to invoke this clause but were prevented by sellers, which led to a minor claim for breach. One sees at paragraphs 180 to 183 of the award. For present purposes, the deployment of buyer familiarisation representatives is a distinct fifth type of expense that may be incurred by buyers in preparation for taking delivery of a ship. So we will come back to those 5 categories of expenses anon. My third section is to address the ordinary and natural meaning of clause 14b. We cover this at paragraphs 10 to 22 and especially 13 to 18 of our written case. It's pages 40 and following. As a preliminary observation, it may be common ground that the ordinary and natural meaning of clause 14b covers or can cover compensation for loss of bargain. We say that because the latest iteration of Seller's case comes close to an admission that the ordinary and natural meaning covers loss of bargain. Sellers say, where there has been a repudiatory breach, albeit one that was unaccepted because the only termination was a clause 14a cancellation, then clause 14b and its wording does cover loss of bargain. We say sellers are right to recognise that the ordinary and natural meaning of the words extends to loss of bargain, but are wrong to impose a prior repudiatory breach as a precondition of recovery of such loss of bargain under that wording. So our case on the text is at paragraph 14 of our written document, page 42. The ultimate question is the meaning of the widely drawn phrase due compensation to the buyers for their loss and for all expenses. We make 5 main textual points. First, the phrase due compensation in clause 14b is not confined to compensation that has already accrued. It means proper or appropriate compensation. That was the view correctly taken in both courts below. It's paragraph 71 to 72 in the Court of Appeal and 45 Roman 1 in the High Court. Due compensation is a somewhat old-fashioned phrase which has featured since the original NSF form in 1956, as one sees from a copy of that form at page 1152 of the bundle. But pausing here, we say that Seller's new hybrid case comes unstuck on the word due. So if one looks, for example, at paragraph 76 of their written case on page 28.
Is this still your first point?
Yes, thank you. It's addressing due compensation.
Which paragraph in the appellant's case?
76 on page 28, please. They say that where there is no repudiatory breach, due compensation cannot include loss of bargain because that would not be recoverable at common law. But lower down the same page at paragraph 80, they then say clause 14b does allow for loss of bargain where there is an unaccepted repudiatory breach, to which Seller's own objection could then be made, namely that loss of bargain would not be recoverable at common law where the repudiation has not been accepted. So we do say that the word due here becomes the focus or manifestation of Seller's inconsistent interpretation. Just as the wording sometimes covers loss of bargain and sometimes doesn't. So here the word due is sometimes given one meaning, sometimes another. They appear to rely upon it, here at least, as meaning due at common law as a key starting point to exclude loss of bargain absent repudiation. But they then ignore that when saying loss of bargain can be recoverable in a modest extension as a safety net where there is an unaccepted repudiation. So we say, rather than this Schrodinger's cat, as we put it in the written document, the better interpretation is that consistently given below, due just means proper or appropriate compensation.
I think your opponent says fair or appropriate. Is there anything in the distinction?
No.
No, it doesn't. He doesn't seem to maintain the sort of common law due analysis that you're shooting at the moment.
That may
Or at
be
least
right.
not already.
That may be. My second textual point is to emphasise the unqualified reference to their loss. To echo what my Lord Burrows said, we say that would be understood by the reasonable person to mean the loss in fact suffered. Whereas here, loss of bargain is in fact suffered, it is within the natural meaning of their loss. That point on factual causation is well made in the Court of Appeal at paragraph 77. Factual causation is made good where clause 14b is relied upon following cancellation because buyers do not get the vessel for which they contracted by reason of seller's negligence. And that is why we say sellers are wrong to say the focus of the clause is late delivery. The clause contemplates two different outcomes. Where there is no cancellation, late delivery. Where there is cancellation, non-delivery. Sellers accept that if clause 14b said loss of bargain, then that would be recoverable. That's paragraph 85 over the page on page 29. But we say loss and all their expenses is wider than, and so encompasses loss of bargain. The third textual point is that the meaning of their loss, namely the loss in fact suffered, is supported by the prior word, compensation. The word compensation brings to mind the compensatory principle. Buyers are being compensated, which in the sale of goods context, where there is an available market for goods, as here, engages the normal market measure. The fourth textual point to emphasise is that the extension of the remedy to all expenses militates against the exclusion of loss of bargain. The clause would be in tension if buyers could recover all their expenses in fact suffered, but not the conventional type of market loss suffered where there is non-delivery following cancellation. The fact that wasted expenses may be recoverable under all expenses also leads to the need to give separate content to the word loss in the event of cancellation. That point was made in the Court of Appeal at paragraph 88. And we say, in the event of cancellation, that is best done by loss encompassing loss of bargain. And we'll come back, as I say, to where all the expenses fit in light of what we saw in the MOA. Meanwhile, the fifth and final textual point is to respond to Malone and Friends' reliance this morning on the whether or not buyers cancel wording. This was dealt with in the Court of Appeal at paragraph 73 on page 92 of the bundle. The purpose and meaning of that wording is to clarify that there is a remedy in either event. It is not, in its purpose or in its interpretation, apt to mean that the same loss is recoverable.
Well, there is compensation for loss in either event, but it may not be the same loss.
Exactly.
Yeah.
So those are the textual points, and I was then going to move on to the consequences of the competing interpretations, which is a more involved topic.
That might be better done at 2 o'clock.
Thank you.
Thank you. Court will adjourn.